Okay, all right. What's it called? What's your company called? Dimension. We do a lot of work on drones regulatory. Sure, understand. Understand. Yeah. Wait, did we miss out anybody? I think, yeah, sorry. All right. We, okay, sure. I think you left. Great. All right. Thank you guys. Thanks for coming in. Um, so very quickly, we were just setting up our presentation, but what I want to really uh, also get a sense of is are there any particular aspects that you want me to cover uh, apart from regulatory stuff? Because regulatory, I understand you will have a couple of, I mean, different startups will have very different regulatory challenges. So happy to talk about it briefly, but more so one-on-one after the session. But what I'm going to largely cover are general issues that startups often face or don't know they want to prepare for, they need to prepare for. There are a couple of things that I want to talk about, starting with the need for having co-founder agreements or need for structuring a co-founder arrangement if you have any co-founders in the company. And I cannot stress enough. So if there is one thing, if of the 8 things that I'm going to talk about, if you were to ask me what is that one thing that I really need to care about, if I don't have the time or inclination for the rest, it has to be co-founder relationship structuring. And I can give you stories and examples of how things go really wrong if you don't prepare for a good co-founder or don't structure your co-founder relationship. The other big part of my talk could be, if you want me to speak on the what are the things that you can look out for in your term sheets, investment term sheets. But I do realize that most of you are at a pre-investment stage. So if that is something that you're looking at, if most of you are looking at in the future, I can spend more time on it. The third big thing that I'm going to talk about, I'm going to devote more time on, is IP. When do you start thinking about IP protection? What is the right time? And there's some science to the timing as well. What is the nature of the IP you need to protect, and stuff around that. The fourth thing we can talk about is agreements. Generally, what kind of agreements you need to have with third parties, whether it's your employees, whether it's your investors or vendors, suppliers, customers, website terms and policies. So these are some of the big items that I'm going to talk about, right? And you can tell me what you need me to emphasize more on or less, and I can accordingly move on that. So just give me one second. Sure, that's fine. Sure, we can definitely talk about ESOPs. Okay, all right, all right. Sure thing. We can talk about that. Please. Okay, certainly. Sure. So I've actually spent a lot of time as a lawyer in Singapore before I moved to India. So certainly happy to we can talk about it generally. But any particular challenges that you're facing, or just generally you want to understand about? Okay, sure. I think I'll need a little more context as well to that, so we can possibly have that conversation after the talk, if that's fine. Because it may not be as relevant to everybody else. But yeah, happy to do that. Please. You had a question, or you want? Okay, sure. Have you registered already? About to. How many of you here have already incorporated a company, and everybody else is running without a company? So do you have a partnership structure, or running as a proprietorship? Uh, okay, so I think that's the first thing I would like to really talk about, right? And I thanks Rick. So the slides are up. Um, Before anything else, let me also just take a minute to introduce ourselves. So, well, I am one of the co-founders of a law firm called TRA. We are based out of Delhi. What we do is we have a very deep focus on startups and technology startups in particular, but also a lot of non-tech business. What we do for with these companies is primarily one big part of it is venture cap investment round representation. So we represent the promoters, which yourselves, all the investors, in putting together the documentation you need for the investment. So the investment agreement, the shareholders agreement, etc., and help negotiate to close the deal. The second big part is business contracts. So we help on various kinds of contracts, whether it's ESOPs, co-founder agreements, vendor agreements, customer contracts. Third is IP, patents, trademarks, copyrights, when to and how to protect your brand. And also niche regulatory work, which is if you are operating in an environment in a regulated industry, particularly fintech, for example, is a highly regulated industry. And so how to navigate the regulations if you're wanting to do something which is cutting edge or new or not provided for by the regulations. How do you go about it? How do you mitigate the regulatory risk? Um, so yes, that's what. So that's a brief about us. We uh, won the Startup Law Firm of the Year runners-up, awarded by Thomson Reuters, ranked by VC Circle as one of the top investment advisors. We wear this as a badge of pride, but we advised on the world's first private moon mission and negotiated the contract with ISRO for the launch. Um, right. So now coming to the presentation. Um, well, I was going to talk about eight, but there are two bonus pointers here. The first one, as I said, is if nothing else, the first one is the most important. Not making the deal clear with your co-founders, and I can't stress enough on the importance of this. So let's start with that one, and I just want to show you a very quick clip. Um, just a sec. The speaker work. Don't worry, we can skip it if it's going to take time. So this is from the movie Social Network for those of you who guessed. But this is just one example or one story in my kind of repertoire of stories that I have on co-founder disputes. Uh, in my experience, one of the most common reasons for startups failing that I've seen are because of co-founder disputes. Uh, in fact, there's an example that I give very often is about, sorry, please. Sure. It will. Well, I mean, depends what family. So I get this question a lot, right? A lot of co-founders come to us and ask if, you know, we are friends or we've known each other for the last 10 years. Does it matter? And I'll give you examples of where or why I think it matters a lot. But just let me kind of move in a certain order. Have we already?
Mark!
He's wired in.
Sorry?
He's wired in. Is
he?
Yes.
You issued 24 million new shares of stock.
You were told that if new investors
How
came
much
along...
were your shares diluted? How much were his?
What was Mr. Zuckerberg's ownership share diluted down to?
It wasn't.
What was Mr. Moskowitz's ownership share diluted down to?
It wasn't.
What was Sean Parker's ownership share diluted down to?
It wasn't.
What was Peter Thiel's ownership share diluted down to?
It wasn't.
And what was your ownership share diluted down to?
0.03%.
You signed the papers.
You set me up.
You're gonna blame me because you were the business head of the company and you made a bad business deal with your own company?
It's gonna be like I'm not a part of Facebook.
It won't be like you're not a part of Facebook. You're not a part of Facebook.
My name's on the masthead.
You might want to check again.
It's because I froze the account. I'm not signing those papers.
We will get the signature.
And I'll bet what you hated the most is that they identified me as a co-founder of Facebook, which I am. You better lawyer up, asshole, because I'm not coming back for 30%. I'm coming back for everything. Mark!
Okay, so just one example of a situation where either you don't have an agreement or you have an agreement which has not been properly structured or negotiated, keeping in mind the interests of all the parties, right? This is one. I'll talk about another example that I often talk about in these sessions I do, which is a client of mine actually who was running a very interesting and then successful company in Bombay, two co-founders, both having an equal shareholding in the company. One of the founders, 6 months through, decided to take a short vacation to Europe, and kid you not, it's been 2 years and he's not come back. But what's interesting is the guy's still sitting on 50% equity, right? And the company's shut down now. But what's important to note is that when you start a company with a co-founder, friends, family, or otherwise, often happens. I mean, the journey of a startup is challenging, right? And people, through the course of the journey, figure out that, well, one, this is maybe not for me. Second, maybe I have better opportunities. Or third, or whatever, it's not working out between the co-founders. Whatever the reason is, but this happens often. The problem, however, is that if you do not have a mechanism which has been pre-agreed to take care of the equity which has already been allotted to the co-founders, what do you do about it? So you have a situation where a co-founder has exited or is not spending as much time or is not willing to spend as much time or is promised you that he'll quit his job, his daytime job, to join you once the business starts taking shape, but he does not because he chickens out. What happens to the equity? And this is a disastrous situation for any startup to find itself in, because if you have a 50, 30, 20% equity stake, giving to a founder who is not contributing to the business, I think the business is dead. One, because then there is not enough incentive for the other co-founders. There isn't enough equity then to dilute to future investors. And third, even investors don't want to touch a company like that, because then investors don't want to dilute their co-founders beyond a point. And where is the room for it if one of the co-founders is sitting on 50% and not contributing to the business? Are we clear so far? So one thing that we do, and this is in the whole host of things that we provide in the co-founders agreement, I think the most important thing that you should all be very careful about is this part of it. One way to structure this or to kind of resolve these kind of issues is what we do is, it's called as vesting of stock. Okay. Does anybody know about vesting here, or just tells me where, where to start from? Okay. Right. So basically vesting of stock is supposedly going back to the situation I was talking about, two co-founders holding 50% stock each. What we do is we lock in that equity which is given to the two co-founders. What that means is you have 50% equity, but you cannot sell or transfer that equity. With every passing month or 2 months or quarter, we will start releasing you a small portion of that equity, which can be transferred. So let me play it out. Supposingly, we say that you have a 3-year vesting period. We say that you will get your 50% in entirety only if you stick around with the company for 3 years, or 4 years, or 2 years, whichever way you want to structure it, right? So 3 years means 36 months. We say that we will, every month, we will release you 1/36th portion of equity, provided you are working that additional month, right? So if one of you decides to quit after 1 year, you are entitled only to the equity which has been released, which you have earned in the first year, which is 12/36. Clear to everybody? Supposingly, before the 12th month, this employee is thrown out of the company for reasons of fraud. So we can structure those kind of situations. If you are thrown out for fraud, we say that, well, you're not entitled to anything at all. 36th portion of your equity which you have earned will not be given to you, or it will be given to you, but maybe you'll not get all of it. You'll get half of it. So these are the kind of structuring that we do based on, after evaluating the circumstance, after interviewing the founders, stuff like that. So this is how we vest equity over a period of time. Also, what we do is typically there's something called as a cliff period, which is the equity will not start releasing to you in the very first year itself, because the philosophy is like you should have, if you're a co-founder, you should commit at least 1 year or half a year, start to demand something back from it. If you've not even spent 6 months or 12 months in the company, then you've added no value really. So we don't want to give you equity only for 2 months or 3 months of your working in the company. Does that make sense? Is everybody clear on it? If there are any questions, I'm happy to take them as we go. Any questions, please? Sure. So typically what happens, no, are you talking in terms of the cliff and vesting only? Right. Stake sharing. See, I'll tell you what. So the stake will be shared as you have negotiated with the investors and between the co-founders. But what happens to the vesting period? Because you're already through 6 months, right? For the 6 months, you've been completely locked in equity so far because it's part of the cliff. And suddenly an investor comes in. Typically what happens is that sophisticated investors or institutional investors, maybe not angels so much if they don't understand this, but sophisticated investors will typically start or restart the vesting all over again. Because see, it's very important from an investor's point of view that your equity is not given to you upfront. Again, the same concern. What if one of you leaves, right? The investor is in a situation in a company where one of the co-founders is not contributing, but sitting on a major stakeholding. So typically the investors will anyway bring it in. And that's why this becomes very important, even at a pre-investment stage. Because if at a pre-investment stage only your co-founder leaves and you didn't have a vesting, I think investors are less likely or are going to find you less appealing to invest into. However, just one more thing. If the investor is coming in at a much later stage, say after 2 years, you can or 1.5 years, you can always negotiate saying that, listen, I'm not going to restart the vesting. I have already, stuck around with the company for a year and a half. We are going to continue as it was. So it can be negotiated. Yeah. Any other questions around vesting? Sure. Sure. Absolutely. And Okay, so there are two things, right? Expensive and not expensive lawyers is one thing, and good and bad lawyers are another. Whatever, whether you pay more money or less money, don't go to a bad lawyer. But yes, you can always find lawyers who are not that expensive. Well, I can also give you some hacks where you can avoid going to a lawyer maybe. So I'll talk about that. It's a great question. See, one is that yes, you are in the initial stages of your company. You're more inclined to spend time on product and things that really, really should matter, right? But having said that, Savrin invested his $10,000 when he was at Harvard, and ultimately to find himself in a situation where he's diluted to 0.03. Ask him whether it was worth it. Would that additional, whatever, 50,000, 60,000 rupees of in dollar terms, would it have been worthwhile when his stake was diluted by a couple of $1 billion or more? Definitely, right? The other thing is, what if you don't have the money yet, right? Or you're not sure whether this business is going to even take off. My suggestion to you is this. Even if you don't want to go to a lawyer just yet, definitely document co-founder arrangements. Even if you document that on an email and exchange that email between your co-founders, can actually go a very long way, okay? One is, there is value. See, to enter into a contract, you don't necessarily need a contract which is written down on paper and which is signed by you. Even an email can actually constitute contract if both the parties agree to the terms. If both parties see it as a binding document, that is also a contract. So by all means, if you're not going to a lawyer, understand what I have to say here, read up a little more on the internet, and draft out your own thing in simple language. A contract can also be very simple to read. It doesn't have to be legalistic and complex. So do a simple email exchange, right? The other thing, we don't only prepare for a situation which goes to the court. That is really not in my mind when I'm advising you as a lawyer. Most often than not, even if you have a document and you have a situation, you will probably not go to the court, and I'll advise you not to go to the court because many times it doesn't make sense, right? But the advantage of having a document is that when you have a dispute or an ambiguity, it is a great guiding, it's a compass, right? It is something which co-founders go back to and say, well, you know what? Yes, we had agreed on this. This is not an issue I can make with or fuss about. Many a times you may have agreed to something orally, but there will be an ambiguity until and unless you have actually sat down together and written it down. So to avoid those situations, it is always better. It really brings out a lot of clarity in the co-founder relationship also. So I think even between your question, friends or family, and family is the most dangerous because people often don't talk about things. Because one, it is a hard conversation to have, and second, it's a hard conversation. You can't openly talk about a lot of things, right? The trouble with that is you may go 6 months down doing your business, assuming that it was an unsaid understanding that we are going to, for example, West, right? But it doesn't work out like that. If you've not discussed it properly, it is always going to lead to a dispute, and within a family or friends scenario, it can always get murkier. So could you be a little louder, please? Sure. Okay, so these are, see, when I'm talking about co-founders, this applies when you have a co-founder, right? So if it's a one-person company, you're a single person, you don't have to agree with anybody else. You run the company the way you want to. You quit when you want to. Well, the moment you have somebody in the company, even if not a co-founder, but somebody who has a stake in the company, I think it becomes important enough to document it, right? Because once you have equity, there are bound to be disagreements. Equity is, I mean, sharing or splitting the company, right? So you need to have some written thing. But I will, by the way, also talk about one-person companies in the next point. I think it's very important to understand. In my view, one-person companies still don't make sense. Yeah. So we'll just come to that. Yes, we often do that. So if supposingly one of the co-founders doesn't hope that doesn't happen, but you die or you have a disability or you cannot attend to the business anymore, we provide for some compassionate grounds as well, wherein the equity can be passed on to your your heirs, or we can provide that you do not lose out all your equity. You still earn the equity, supposing there's a disability, right? Because of which you can genuinely not attend to the business now. So we will be a little more compassionate in the way the equity will be distributed to you. So we always structure these things. Right. Sure. Right. So to a nominee upon death or even otherwise? Yeah, I think that's something we often suggest. Yes. And see, that is why it's important. What we help do is there is no one standard vesting structure. Often we try and understand these kind of things that co-founders, what is important to the co-founders, and then accordingly structure the arrangement, right? So I'll structure the vesting period. Please. Yeah. So great you ask. Are you a lawyer or a CA by any chance? Sure. So what happens is that when you do typically one ground rule, your memorandum and articles of association always supersede any other agreement that you will have. Okay. So here's the thing. Your 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 articles can provide for co-founder terms, but somebody needs to do the thinking, right? That how do you draft the articles? If you have not thought about it, if it's a model AOA which everybody else uses, it's not going to work because it doesn't have these kind of provisions. But if we want to structure the co-founder relationship, we can structure it in the articles also. No, I will recommend having a separate co-founders agreement for the reason that, see, understand, an article is not an agreement between the two co-founders. So if one co-founder needs to sue the other co-founder, he needs an agreement between him. What we do is we draft the agreement and then we also replicate the terms in the articles so that you're covered from all sides. But of course, if you're at a stage where you are too early, you don't want to spend too much money in drafting both or don't have the time to do that, even a simple email, right, where you document these things can really go a long way in maintaining some sanity in the co-founder relationship. Yes. So yes, that is possible. That is the least you can do. That does not, of course, provide you a foolproof solution. If you tomorrow go to the court, for example, and you don't have a properly and comprehensively drafted agreement, obviously there'll be a lot of loopholes. It won't be properly drafted. You don't have the experience of doing this before. Fourth is your articles will prevail over the email, so there could be conflict between the two documents. So all of that is there. But the least you should do is the email. Right? Question, a lock-in. The vesting period, you mean? Or yeah. So typical vesting period that has become a standard in the investment circles is about 3 or 4 years. 4 years more often than not. Sorry. Can you hear me or? Okay, sure. I'll do that. So, and let me know if it's not audible still. So typically what's become standard is 3 or 4 years and with a 1-year cliff. So 1 year, the equity does not vest. After that, it begins to vest for the next 2 or 3 years. Yeah, well, he can always sell the equity which is already vested. See, so the equity which is released to you, you can sell it, but you don't have the right to sell all. I'll give you live examples. So we're working with a company right now, which is where the CQ has decided to quit after a year's time, right? So now what happens is if we did not have a vesting, this guy could have continued to hold his 10% equity, but now because he has worked only for 1 year and he has earned only 3% or so, that's a good situation to be in, right, for the company because he doesn't go back with all the 10%. Now you have the buffer 7% to give and bring another CQ instead. So vesting is really, really very important. You can vest both, right? But I'm right now talking about stock because we're talking about co-founders, and co-founders typically have equity upfront. So, but even with ESOPs, that's what we do. I mean, we vest ESOPs. You don't just you can give ESOP both ways, but vesting is yeah, sure. Sorry, you had a question. Non-performance, you can provide for termination clauses. So, two questions there, right? Who will determine non-performance? How will you determine non-performance? And third is, if there is non-performance and you're terminated, what happens to the equity? Do you earn for the time period that you were there in the company, or you earn nothing at all? So these are the 3-4 things that we think about. Typically, we'll say that the determination of non-performance should be either by the board, but if it's just 2 people or 3 people, it may not work. So we can provide for a determination by an outside panel. We can decide that by, so we can structure parameters there. Yeah. Sorry, there was a question you were trying to ask. Yeah. Yes, that's what we do often. So what happens is that supposingly, so clawback is basically the shares return to the company, right? So if I have 50%, I quit the company and I have earned only 5%, what happens to 45? That 45 will either go back to my other promoter or it will go back to the company. We can structure it either way. Okay, so there are situations where, like for example, fraud. We'll say that doesn't matter that you spent 1 year with me, because you've committed a fraud against the company, I'm not even going to give you your 5%. So I will claw back the 5% also. It can be, usually we don't do that because it becomes fairly onerous. I mean, think about it, right? I mean, if you are the founder and you are unfairly thrown out, for example, should you get nothing at all for the 1 year you spent with the company? So typically we don't do that, but definitely we can structure it that way. There's nobody saying that you can't do it. You can determine whatever contract between the two of you. No, I mean, right. So yes, there is a procedure for not for earmarking ESOPs really. But can I just take the questions relating to ESOPs in one go? And I think there were other questions here also. So do remind me. I'll talk about ESOPs, but one thing very quickly I'll say is whether you should separate out a pool of ESOPs upfront or not is a question that I like to often throw at promoters. I often feel like in a new company, which most of you are, 1 month, 5 months down the road, unless you have employees who really deserve, who you want to give ESOPs immediately, you should not create a separate pool. And if you like, I can talk about it a little more when we talk about ESOPs separately. So just yes, exactly. So maybe I can then talk about this right now because this is exactly what I was going to say. See, what happens is when you're doing an investment round, typically investors will come in and say that, listen, you should create a pool of say 10% equity for ESOPs. You separate it out. Who will dilute? Investor will not dilute, the promoter will dilute. So promoter supposedly is giving 20% to the investor, an additional 10% he will give for ESOP pool. So you are actually diluting by 30%. Now, why does the investor need that 10%? Very honestly, in my experience, companies even 2 years or 3 years hence are often not able to use their 10% ESOP because it's a big chunk of equity, right? So how many employees and senior employees you will have to give out that equity? So why does the investor ask for it? Is because he is trying to safeguard against a situation where one of you, the co-founders, exits. Because you're an expensive guy, if you leave, he will have to dive into that 10% ESOP pool and get another senior guy, okay? The problem with this is, and the reason why I don't like promoters creating a pool upfront before the investment round is there's a very small chance, most investors will force you to dilute, will force the promoters to dilute. But we have in certain cases been able to negotiate even against larger investors that listen, the dilution should be equal between the investor and the promoter. It's a very rare chance. But that can happen only if you have not already created the pool. If you've already created a pool, there's no negotiation around it, right? So that's why we advise against, what you do is if you want to give small time ESOP, create a 0.5% or 1% ESOP pool. Don't create a 10% pool. That answers? Okay, any other, I think I'll move from vesting and by all means we can come back to this. So, I mean, whenever you have a question, ask. I'm just moving from vesting to the other topic. Sure. Vesting is lock-in. Vesting means lock-in only. Sure. Right. You mean not having the same term? Right. Sure. Has everybody understood the question? So basically what he's saying is you have a 4-year vesting, right? Which is for the purpose of what I just described. Some investors say that beyond the vesting also, your lock-in will continue for 2 years. So you can't sell the shares even after 2 years. Now, my typical argument to these investors is then what is the point in having a vesting, right? And we try and negotiate that. But there's a reason why. See, what happens is, the reason for, very honestly, no investor is actually expecting or even wants that you exit you sell your released shares in the first 2, 3, 4 years or before the investor himself has exited. They want the startup, the promoter, to be locked into the company until they have exited. So their reason for vesting stock to you is not so that okay, you have earned 2%, you should be able to transfer that 2%. They don't even want that. They will still lock you in. The reason why you have vesting in that case is for the reasons when a promoter quits or terminates, is fired. How do you calculate what is the equity to be given to the promoter when you have quit the company? So the way we do it is supposingly, I mean, as I described, if 1 year down, you were fired from the company for reasons of fraud or otherwise, we have a mechanism to calculate the equity that should actually be given to you or that should be clawed back by the company. Does that make sense? So it is for that, it is that formula really. I mean, other than practically speaking, you still can't, you're still locked in and you still can't really sell your shares. No, correct. Yeah. Correct. That is right. Yes. Yeah. Yes. Come together as in both operate. So even though the shares have been vested, you still can't sell your shares. Yeah. 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 That's right. I've seen a lot of those situations, and that's what I was trying to explain the rationale for why they do it. Right? We can talk about this a little more, but it slightly gets technical, and there are a lot of situations that I can narrate to you on how this is structured or what are the typical structures. We can chat about that. All right. So let me move on. So co-founders agreement, key thing is vesting, but there are a lot of other provisions you need to really think about. Most important is non-compete. What if the housing co-founder leaves, and obviously the next best thing he can do is to start a competing business in property rental, right? For example, so non-competes are very important, and structuring of non-competes is also something which is very important. What is it that you can do or cannot do? And for how long can you not do it? Under the law, there are peculiarities which say that supposingly if I'm fired as an employee or as a co-founder, you would ideally want to say that, well, you will never start another housing rental company in your life. The law says you cannot have that provision because under the law, it's a public policy thing that you don't, I mean, ultimately all this guy knows is housing rental. He doesn't understand any other industry. How can you stop him from doing the one thing that he understands? So what we typically do is we try and provide a reasonable time period for which you can have the non-compete. So maybe 2 years, 1 year. There are some other nuances to it. The reason I'm telling you this is that this non-compete needs to be thought through a little bit from a legal perspective. Other provisions that are important are confidentiality. What happens once you quit to the confidential information? You need to erase that information. You need to give back the documents. You cannot solicit employees from the company. You cannot take away, poach employees from the company. You cannot poach customers from the company. You cannot even poach vendors, for example, in certain cases, we can also provide for that. So these are some of the clauses. We can provide for it in one agreement. There's no reason to have. Yeah. We provide for it in the co-founders only. So there are multiple different kinds of things that we take care of in the co-founders. Another important one is IP, which is very, very relevant. Now imagine, a lot of times what I see happening is one of the co-founders develops a product, and then another co-founder comes and joins him. Now this IP was developed by one person. It is possibly even registered in one person's name. To make sure that this IP is assigned to the business is absolutely important. Otherwise, no investor is going to touch you. Second is, what happens to the IP which is developed post you coming together? So in due course, as one person is developing IP, the other person is the business development head, right? He's not developing IP, but the IP should be assigned to the company. That's critical. So co-founders agreements provide for a number of these kind of things. If you can do this in an email, great. I mean, do that to start with. Typically, we provide very comprehensive, I mean, depending on the stage of the relationship, depending on the criticality, we can do very simple agreements, 5, 10 pages, or we can do very comprehensive 60, 70 page agreements also. So it depends on how much, the co-founders are, how much is at stake really, right? Okay, so if you're already raising investment, Good question. Typically, an investor will already provide for some of these things which I've spoken about, because these things concern not only the co-founders, also the investor. It is also the investor's interest that you don't compete with the business. It is also his interest that your IP is assigned to the business, right? So an investment agreement will anyway provide for these. But there may be certain things which are just between the two of you, which an investor is not worried about. So for those few things, you may still enter into a simpler co-founders agreement. But largely, if you're in like an investment stage, you can avoid it, right? The second point that I want to talk about is not starting the business as a company. And I note that a couple of you do not have a company incorporated yet. Now, one thing generally is that when you're starting out a business, it's just at the idea stage. You are in a proof of concept stage. You're still figuring out whether this will ever gain traction, right? You are okay not incorporating a company at that point, because companies, once starting a company is a pain. It can take time, 1 to 3 months, maybe more at times. It costs you money. And once you start a company, there are regular compliances, and shutting down a company is not easy. So mind you, if you have a company and you don't shut it down, once you close the business but not shut down the company, you have to carry on the compliances like filings and all. Otherwise, there's significant fine and liability on you as a director. So you should never stop compliances. And that's why you should know when to start a company. But at the same time, the moment you are confident that I want to carry on this business and take it to the next level, don't wait to incorporate a company. And the reason is, no investor is going to put in money into any entity other than a company. They will not invest in a partnership. They will not invest in a limited liability partnership. While technically they can, but a limited liability partnership is still not very appealing to investors. The only entity they will invest into is a company. And imagine you are in an investment round and it takes you 3 months to start the company. That delays your investment round by as much, right? Also, if you have already grown your business, and I've had clients who have, say, were running a sizable business as a partnership. Now to start a company at that point and to transfer the business from the partnership to the company can be very tax inefficient. There can be a significant expense in transferring business from a partnership or a proprietorship to a company. So that's why it's very important to time your company incorporation right. Okay. Any questions around incorporation and stuff? Okay, so really, I mean, we have had situations where investors do invest in Section 8 companies. See, the thing is this: a Section 8 company, by definition, is a not-for-profit. So if somebody is investing in that business, he's not investing in for profit, which is of course a smaller set of investors, and that's why. So it can happen if you're building a for-profit business. Yes, a not-for-profit, but for a for-profit, it doesn't make sense. Any other questions around this? Okay. All right. So sorry, we had one point. Somebody was talking about a one-person company. Now, under the New Companies Act, you can even start a one-person company. Earlier, you needed at least 2 people as directors and shareholders to start out a company. Now, even a single person can start a company. The challenge with that is, imagine tomorrow you're having an investor. Either you want a co-founder later on. You have to change the company itself, which is problematic. The second is, if you have an investor coming on board, typically, the investor now becomes the shareholder in the company, right? So you can't live with a one person. Second is, investor will want a director also on the company. So a one person will not work at that stage. And that is why, I would suggest that unless you are sure you are not creating an investable business, it is not a business in which you will raise funding and not a business in which you will add co-founders, you should not go for a one-person company. Is there any questions around that? Not evaluating regulatory issues relating to your business. I actually had more slides. So not evaluating regulatory issues. I don't think I need to spend too much time on this. But really, as fintech companies particularly can be fairly regulated. Somebody here is setting up a peer-to-peer lending company. There's absolutely no regulatory clarity on whether that business can be done, in which manner can it be done or not. Think of an Uber or an Ola, which has gone through. Uber today has a 15% public policy team in-house, just handling government relations and doing public policy, right? So these are the kind of downsides of operating in a regulated industry. And you need to be very sure that you've spent time understanding the regulations that will impact your business. Also, you have spent time understanding the regulatory on how the regulatory environment will pan out. So think of it. When an Uber came into the started business, there was really no direct regulation affecting it. Like arguably, they said, we are a tech company. We are not a taxi company, therefore we don't have to comply with the taxi regulations. However, when you take such an aggressive call, I don't even think it was an aggressive call. I think it was a very, fairly reasonable call. But when you take a call like that, you need to to understand who are the stakeholders in this industry who are going to be agitated by this. In an Uber example, the obvious stakeholder were the Kali Pili taxiwalas, who are going to be agitated, who are going to go on a hartal, and who are going to provoke the government and the politics to then start clamping down on your business, right? So you have to prepare for for what the concerns that might come up over a period of time and find solutions to those upfront. For example, just to give you an example, I'm not here passing judgment on what Uber did right or wrong, but just for example, had Uber anticipated that there can be a threat of safety to my passengers and had upfront put up an emergency button in the cab, or had a team of one person manned in each city, or was working with the police, or was helpful to the police in tracking down the taxi faster than it did, I think these concerns may not have, those issues may not have arisen in the very same manner as they did. So it's often important that either if you're in a regulated industry, you understand the regulations properly. If it is an unregulated industry, but there could be concerns, you understand those concerns and prepare for those, right? I will not spend more time on this, but happy to talk to you guys on a one-on-one basis on the regulatory issues your own business is facing, because it's a very kind of sector-specific discussion that I'll have to have. Okay. Going to the next point. Coming up with a name for the company which has trademark issues or domain name problems, absolutely critical for a consumer-centric business, right? I mean, if you're starting a fashion label, for example, and you do not have, if you are, I mean, there are other businesses where you can possibly change names later on and survive. But if you're starting a fashion label or a fashion e-commerce company, and you figure out later on that the name you have is actually infringing on somebody else's name, that is a big challenge for you. Now, understand that the company name that you set up, that you obtain, is being approved only by the registrar of companies. It's not clear from a trademark perspective, right? So you still need to figure out. Also, what's important, I'll give you some examples where, very interestingly, there's a client of ours which has a name with a play on the word fox. It's very different. It's a very different industry. They do something in, a vertical which is unrelated to Fox movies completely. But Fox wanted to take them down, right? So one has to also be clever in understanding that this name, will it be of interest to some large major? Maybe in my industry, may not be in my industry, but am I likely to run into a problem there? Or there may be a name which is not exactly trademarked by anybody else, but then it sounds similar, right? And the test there is, is the name so similar that it is likely to cause confusion in the minds of my customers, right? That is the test. But typically you can think about it yourself. If you think you need lawyers, you can get an opinion, please. That's right. Yes. Yes. Absolutely. So I will, yeah, great question, and there's so much I can talk about this. How important is IP to everybody here? And I'll accordingly decide how much time we need to spend in the open group. Is everybody, I mean, many people also tinkering with the idea, want to understand about trademark and issues? I will come to patents separately. Yes, so that's a separate conversation. But trademarks is something which is relevant across to most people, I think. Yeah, after this. Sure. No, so any mark, whether it is your logo, it is your company name, it is your tagline, it is a brand label, it is a sound even. So think of, say, Starbucks. Not only is the logo, but also the color green used in a particular way in all their outlets, wherever you go, could possibly be a trademark. A particular music, a jingle like Airtel plays, right? If you use the jingle to sell something else, people will potentially get confused whether this is an Airtel brand or not. So even any mark, whether it is sound, a graphic or a name, which has an association with the business of the company, such that customers associate that sound, that mark with the business, is a trademark. Okay. Yes, they're two separate applications. Now, color also could be. So color is more. Yeah, absolutely. Yeah. Yeah. So I'll come to that. So the first question, let me just give a brief, let me just explain how trademarks work, and then I'll come to these more specific nuanced issues. I think it's absolutely important for everybody in the room to understand trademarks, because trademarks are something which impact all of us, because we have a company name and a logo to protect, all of us, right? Immaterial, irrespective of what we are doing. So the interesting thing with trademarks is you have a right over your mark, irrespective of whether you have registered it or not. By virtue of, so whoever started using the mark first, whether registered or not, is the rightful owner of that mark. Even if you had registered the name, but somebody else can prove in the court that he was using the mark for much prior and had not registered it, is actually is the right owner. Okay? In the same domain. So I'll come to this. Yeah, same domain. What I mean by the same domain is, if I am an Adidas and a footwear company, if somebody were to use Adidas, actually Adidas is a bad example. Let me think of something, a lesser known mark. Just give, supposedly, yeah, TRA. How many of you had heard of TRA? It's not a consumer brand. Not many people, right? Nobody, possibly. If TRA is a law firm today, and tomorrow somebody starts to opens a restaurant by the same name, you're possibly not infringing. You're not infringing on my mark, all right? Because it's a separate industry altogether. Going back to the same test, there is no possible confusion, because it is clear to the customers that one is a restaurant, the other is clearly a different this thing. There could possibly not be any connection. But Adidas is a different ballgame, because Adidas is such a well-known mark. If tomorrow I use Adidas to launch a TV channel, very well, I mean, there could be an infringement. So well-known marks are a problem. Fox Movies, the example I gave, is the same thing. Fox says that I'm so well-known, like anybody, whether you open a restaurant or a thela selling chai, people will be confused whether Adidas is doing this, right? And that's where it starts getting tricky. Yeah, so that's interesting. So the thing is this. Firstly, both these companies and marks go back a very long way, right? At the time they were starting, I don't know the history, right? So I don't know if there was any possible this thing. But the thing to remember there is that what Apple, Mac kind of, what they take benefit of is that it's in an industry where one, there is absolutely no correlation, right? The other question with Apple Macs is often that with Apple actually, that you're using such a common name as Apple. Can you potentially use it? And the benefit of that in this case is because you're selling computers where Apple, there's absolutely, it's so arbitrary for the industry that it can be allowed. But if it was, and that's actually the reason why you see a lot of brands these days taking up very arbitrary names. Like, what does a Zumanji mean, for example, or the random kind of names that we see. The good thing with these random names is because they're so arbitrary. One, the possibility, they are fairly unique. therefore less likely to cause confusion with anything which may come closer. And second, because they're so arbitrary, they're considered stronger trademarks. Okay. But anyway, I think we deviated a little bit. So going back to what trademarks is. Yeah, so Big Mac and Apple Mac, completely different industries. I don't know the history. I mean, at what point did did one become a well-known mark or not and stuff? But yeah, different industries, they don't have an issue. The other thing also is, see, understand one thing that, you can also create distinction. So often, many times what happens is that clients will come to us and say that, well, there is a well-known mark, right? Should we or should we not? So you can always create distinction in smaller things, like you will change the spelling a little bit and reduce or mitigate the chances of. So I'm not saying that just because the name is similar and because one is a well-known mark, it will have a better right over you. I'm not saying that. But I'm just saying you need to be cognizant. There are ways to get around it. If you have created enough of a distinction such that there is no confusion, ultimately, then it's not a problem. So we will add some different color to the logo. We'll add a little more, we'll change the font. The bundle of things that we work with the design team at times to increase or reduce the chances of confusion between the two marks. Get around these things. So the thing about what I said is that you may be a rightful owner of a mark even if you've not registered is very important, because often just because you have gotten your trademark search done doesn't give you all the answers. There might be other users who have not registered but still might have a better claim over the mark. So these are things where you need to often kind of do some clever searching. You need to firstly do a good comprehensive Google search. Make sure that you don't find anybody else doing similar stuff, having a similar or confusingly similar name, right? And then do a trademark search, because particularly if you're a consumer brand, get a lawyer to do it properly and get an IP lawyer to do it properly. Don't take your chances. If you're not a consumer brand, you could possibly delay. The other thing I'll tell you is a lot of it can be expensive to get trademarks registered at times. So a lot of guys come and ask when should I start worrying about these things? My answer is, if you are a digital company, because the moment you begin to use your trademark, you already have a right over it. So what you should do is you start using the mark. Even if you're not registering, start using it, because you're digital. The use of the trademark is already recorded in time. It is for the public at large to see. So there's good proof that you started using it first. So it is okay to start using the mark, wait for the time until you get more traction, and then register the marks, provided there's no conflict already. If there's already there are some conflicting marks, then you should go do it immediately. Yeah. The question is of proof. So the reason why you trademark, well, I'm surprised nobody asked the question, then why trademark at all, right? The reason you trademark is because trademark serves as evidence. A government proof, basically, because the government is certifying that you started using this mark before anybody else, right? So the thing is, if you can prove that you started using it first, no, but can you prove? Can you establish that you started using the? No, I'm with you. I'm with you. If you can very well. I mean, even the giving of visiting cards to somebody with my mark, and if that other person can come to the court and testify that yes, I received the mark, is good. But it becomes trickier, right, to do that. If you're digital, there's a timestamp. So it's very easy to prove that yes, this person started using it much earlier, and there are hundreds of people saw it as well, right? So it's easier in a digital company, right? Sorry? Fonts, they form an integral part. So I'll tell you what. If your font by itself is unique enough, maybe you can claim that. But the other thing is, yes, very much. So if, for example, TRA is written in a certain way, I don't know if you can see, it's a different font, right? It's a unique font. If somebody else tries to write TRA in a different font, may not get through. But imagine supposingly somebody has TRAA, right? In the court, there will be an argument that, well, TRAA is very similar to TRA. It spells, but added along with a different color, added along with a different font, maybe you might be able to establish that, no, there's no confusion, and I deserve my distinction. So you can make distinction in your marks at multiple levels. colors, fonts, size of the logo, the additional graphic that you added with the font, all of that goes a long way. Sure. So the point is, one, do you have a market outside of India? Because trademarking by itself is an expensive process, and doing that overseas is even more expensive. So, do you have a market overseas? Do you have a sizable market? Is there a conflict overseas? All of those things need to be looked into for sure. But you can register overseas. Yes. Yes, it does. The nuance there. So, firstly, many countries follow the first use principle. There are countries which don't do it as follow it as well. So, in those countries, that won't be of help. But in other jurisdictions, of course. Possibly, yeah. I mean, I'm not going to give you a definitive answer, but we can figure it out. Yeah, 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 possibly. There are a lot of examples. Yeah, I mean, yeah, just, so much we can talk. No, trademark is only for a mark associated with your trade, hence the name trademark. Yeah, so that's the question somebody else also asked me. I'm just going to come back to that. Company name can be trademark, yes, certainly. Yeah. Not carefully considering IP protection. To answer your question, so there are multiple other kinds of IP as well apart from trademark. One is a copyright. A copyright is a protection over any piece of art or so any literary work. Say you've written a book, say you've created a document, maybe it's a white paper, maybe it is an article, maybe it is a drawing or a design. All of that can be trademark. So trademark is on the aesthetics or the form of what it is, not the substance of it. The underlying idea doesn't matter, right? Now, to who, so talking about, I mean, a lot of fashion labels, for example, come to us and say that, well, we have these unique designs, can we copyright it? In the case of software, for example, you can copyright the software code. The problem is, as I said, copyright is a protection on the form, not the substance. So the substance of the software is still not protected. The underlying idea, the equations are not protected. Because only the way it is written. So very well somebody can write it differently or write it in a different language and get around it. It's a very weak protection. Okay? But yeah, copyright is available. The third thing, patents. Patents are a protection on the substance. Okay? So you've created a new invention, you've created a new product, possibly could be patented. The thing with patent on software is important to understand. In Indian law, you cannot patent a software. Okay, what you can patent is a software hardware integration. If there's a dependency of the software on hardware, that is when yes you can get a patent. But pure plain vanilla software cannot be patented. However, so one thing that if you guys are wondering, if I have a piece of software, how do I secure it? Hard luck. There are much of software, plain software, which is not integrated with hardware, often cannot be protected properly under IP laws. But what you need to understand is that a lot of companies do apply for software patent despite this restriction under law. Why do they do that? Is one, because there's a lot of lobbying against this law, this restriction. There's a likelihood that this law could potentially change in due course. Maybe, who knows, right? The time period for a patent to come under examination from the date you apply is, as of today, at least 4 to 5 years, which is period ripe for a change in the law. So some companies take the bet that, listen, maybe the law changes, I have the money to burn, I'll file patents any which way. Hopefully the law becomes more lenient and it goes through. Second, is some companies file it for its optics, the optical value. That I have a patent pending status unless it is examined 5 years down. They think that maybe it is more appealing to investors. I don't think sophisticated investors go by that. But yes, it could be appealing in certain cases to your customers, to certain vendors, to employees who you want to hire. Those are the reasons why some people burn money on patents. Yeah, so So as I said, it can be copyrighted, but what is the point? Because it's a very weak protection. Somebody could just write the same code in a different language, in a different manner, and get around your copyright. No, algorithms and ideas fundamentally cannot be protected under IP laws. So it sounds very simple. And a lot of people used to do that. They used to say that, well, there's dependency on the memory. There's dependency on the server. I'm using it on a tablet or a mobile phone. The regulators and the law is becoming smarter by the day, and they have started to come down on these practices. But if you can show more than that, so for example, some health tech companies we work with, which have created equipment where you have a microphone, you have a certain special kind of a camera, and there's novelty in the hardware as well as the software. Those are ripe products for a patent under under that law. Business process in India cannot be patented. Yeah, patents on what? There are multiple patents on multiple things, right? I mean, see, large companies, one, they create a lot of IP, and they have the budget also to IP protect it everywhere. So they will probably not go. I mean, companies like Wipro and Infosys, for example, file software patents, plain vanilla software patents by the dozens, because they are able to take the bets on the bleak possibility of a change in law. I don't think a startup wants to approach it the same way, right? So we should not confuse. Yeah. Copying the flow. Yeah. Yeah. So sorry, need something. Okay. So yeah. So that's the thing. I mean, the user experience. So understand one thing: processes cannot be patented as of now, right? Underlying algorithms, ideas, processes cannot be patented. What we could possibly protect for is if supposedly your UX or UI is aesthetically very, very unique enough to stand out and deserve a protection or a monopoly, then yes. So if there's a particular color scheme which is very unique to you, there's a particular way in which the UI functions, which is very, very unique and not, because in the app world, how much can you play around, right? So there's very few apps which I think qualify that test for me. But if you do, certainly you can copyright. Do what? Sorry. Yeah, I mean, unfortunate. If you're not doing that using hardware, it's a hard sell. Yeah, it's a hard sell. Yeah, but think of it the other way around as well. That even if you got a patent on it, you in your possibly you yourself will work on it and replace that technology in 4 months. So when it comes to technology, actually, yes, it is a loss, I think, for the industry, but it's not such a big this thing as opposed to say other hardware companies, because the technology is very rapidly evolving as well. But yeah, I mean, there's not much you can do about it. What you can put in place is physical checks, which is what most people rely on. So as I said, if your UX is very, very unique in terms of the placement of graphics, um, tell me something. Give me an example of one app which to your mind is so stand out that clearly you say, you look at it and you say this deserves a monopoly. Sure. Yeah, that about. The one. No, you can show proof, but what law gives you that monopoly over that? There is no law which allows you. No, what all you can do is just make sure that the code doesn't go out. So there are two ways. So you have IP assignments with your employees and vendors, that the IP belongs to me, even though you developed it or even though you worked on it. Second, there is strict confidentiality and good, well-drafted, comprehensive confidentiality agreements. Third, you have physical checks in place, which do not allow scraping, which do not allow, stuff like that. Other than that, under the law, there's little you can do. I mean, you can have a copyright, you can have a patent, but ultimately, to what extent will you actually get protection under those laws is very dicey. Sure, sure. You're talking about a physical. No hardware integration. I mean, it's no, no. I mean, see, we listen. I mean, I'll tell you what we do, and ultimately, let me give you. I think there's one thing that I should stress upon here, is that don't lose all hope in the sense that there is. A lot of times when we draft these applications, we do show extensive reliance on, how do we say, the cloud, reliance on memory, in a way where there's actually some novelty, not just like you're using the cloud, but the way you're using the cloud is something which is very unique. And there is some hardware novelty also, some minimal hardware novelty. Yes, you can draft these applications intelligently and hope that it goes through, right? Along with a certain leniency which comes in the approach of the examiner over a period of time, because the law is also drifting. In the sense, every couple of months we have a new circular which shows a slightly new approach, where either they are getting more stringent about it or getting more lenient about it. So with all these things together, 5 years hence, when the application is examined, maybe, right? I mean, we do file a lot of these applications on plain software as well. So I'm not saying a complete no, but please bear in mind that you're taking a gamble here. Okay, giving away too much in your angel round term sheet. This is a topic in itself which can go on for hours, so I will not spend time. But one thing that most entrepreneurs do, I've seen, is they feel that when they're doing the first round, the angel round, it is a small amount of money, a small stake. We don't need a lawyer, or we don't need to be advised. And I think you could not be more wrong, for the reason I feel is that your angel round at times can be the most important round you do ever in the life cycle of your business, from the perspective of what you give away. One thing is that what rights you sign up at an angel round, the subsequent rounds, the rights to sign up will always be more onerous than the rounds given in the first one. So if to your angel investors you've signed up a 2x LP or liquidation preference or some onerous right, the other larger investor is obviously going to ask for as much or more. He's not going to reduce the investor kind of rights, right? So that's one thing. The second is, if you have just gotten into a bad deal with an angel investor, you can really go, I mean, it can go really south. For example, at times there is something called as reserve matters in your investment document. Reserve matters are matters where you need prior consent of the investor before you take any decision. For example, if you want to raise another round of funding, you want to change the name of your company, you want to start a new business, you want to take a loan in the company, and now it starts getting more and more micro, right? You want to take a loan, you want to sign a contract worth more than 5 lakh rupees, you want to add a co-founder, you want to hire an employee who you pay more than 15 lakh rupees. All these matters, if they are in the contract, you will need to go back to the investor first. Problem with that: one, your investor does not understand your business. Most like an angel round, the investor may not be as sophisticated. If you raise a round of funding from a builder, for example, who has only built real estate all his life, has no clue, and he starts applying his mind, his thinking to what is the amount of money that you should or not raise for the money, what is the business that you should be in, and he stops you from say pivoting your business. These are challenges, right? So it's very important to have the right set of reserve matters negotiated in the angel round itself. Otherwise, you may not even be able to, because he also has a veto on the next round of funding. Maybe he doesn't even allow you to raise the next round of funding, right? Unless you give him more or stuff like that. So it's very important. Second is, second very critical point is liquidation preference. What liquidation preference means is that if you close your business, if you sell your business, or if you raise another big round of funding, or you sell assets in the company, whatever money comes into the business, first, a certain portion of it will go to the investor. That is fair, because the investor is investing in your business. He wants to make sure he's paid out first, right? But what is that amount of money that will go to the investor is the debate. Should it be 1x, meaning 1 times of the investment amount? He put in 50 lakhs, he gets 50 lakhs. After that, if there's any more money, you take it. Or it gets split equally between the investor and the guy. But sometimes guys will negotiate for a 2x, which is you pay 1 CR or 3x, 3 CR before you start to take any money. I can actually tell you examples of very successful exits where people have made mega multi-billion-dollar exits but have not made money because they had a very onerous LP where the investor took home everything, right? So you can even have those situations practically. But yeah, LP is another sticky point. Please. No, no. I mean, preference shares is only no, that's a different reason. So yes, technically speaking, preference shares give you the right to take your, in the case of winding up, when the company shuts down, preference shares get paid first. But a liquidation preference is a creature of contract. So preference shares is a creature of law. By law, you're allowed what you put in money, what money you put in, to you take it out first, right? In the case of winding up only. But a liquidation preference is a negotiation where you pay the investor first, even if you're selling the company, even if you're raising, you're exiting 50%, even if you're selling your assets. So you have actually negotiated to give money to the investor in a wider set of scenarios than preference shares alone. You get more. Yeah. But also, when you do an equity round, not a pref round, there are enough equity rounds also. Even in an equity round, you will still contract out and get the same rights to pay the investor first by way of the liquidation preference. Okay. Now, the reason why people go for preference shares is slightly different, and I think we can talk about it. It goes on a the provisions that go into the SHA. Sorry, what percentage? Well, there are two. So there are certain angels you would want and you will value because they take a hands-on approach, because they are industry guys who understand the business and add value. At the same time, you will not appreciate an investor who's micromanaging your business, particularly if you know the industry better than he does, right? So that is the distinction you need to make. And you need to understand the investor before you negotiate these reserve matter rights. Yeah, no, I work a lot with various accelerators at both sides, representing promoters as well as accelerators. So the thing is, I've always had these fights with accelerators, who, when I'm representing the promoters, not other way around, but that if you are taking a 2% or a 5% stake in the company, there's only so much that you should get. right? But accelerators are also caught up because ultimately in guaranteeing you investments, they are being pushed from their investors that, listen, this is the minimum I need. So it's always a debate. Um, but ultimately the rights always tie in with the stage of investment and the size of investment and the stake you're getting. Why stage? Because if you're a very early investor, I would typically say that, listen, you are coming in early, you're benefiting from that because you get a huge stake, but you're taking a heavy risk. You come with a high risk mindset, don't ask too many rights here. Okay, that's one. If you are putting in a lot of money and taking a 20% stake in the company, obviously you deserve great rights. But if you're putting in 10 lakh rupees or 15 lakh rupees, I don't think you should be negotiating or you should get much. So really depends on, the size and stage. Sorry, could you? Right. No, no. So I'm not even talking about the stake. The stake is just one part of it. I'm talking about the other rights which you give up, right? There are so many provisions. I mean, we've just touched the tip of the iceberg. There's just so much that goes in an investment. So many provisions in the investment document. So I can't give you a cheat sheet, but surely you can. What you can do is a good guide is you'll find a lot of stuff on the internet. You'll find a lot of stuff on Quora, for example. So each of these provisions, say for anti-dilution or LP liquidation preference, you can read so much on these sites. So there's a lot. I mean, it's just not enough time. Well, we can schedule another. Maybe I can come down again next month and we can do one thing on just angel term sheets because it requires a 3-hour session. I mean, it can't be. We can't touch upon that just in 5 minutes. Sorry. Does somebody else who wanted to raise? So what we don't take up these mandates professionally. But what we do is one because we are very entrenched in the ecosystem. We are very well connected with startups, advisors, investors. We love making those connects where we feel there's potential and a startup needs to be supported, or an investor will love this particular idea. We are happy to make those connects. We help with very few startups with with these specific things with industry insights and stuff. We do it only in two situations. Either we ourselves understand the industry very well because there's some industries where we do a lot of work which are very niche, and we are able to add that commercial insight also. Or at times we get involved with a startup and say we invest ourselves or we take equity in the company in lieu of legal, and then that is when we get engaged more and more. So we are able to add value there because we understand, we have been working in the space for so long, but we'll do it for very few people where we ourselves are very excited, we have a stake in the company, stuff like that, not otherwise. Yeah, so typical information in an angel round, right? Um, when you say angel round, what exactly you mean? You're talking of a 30, 40, 50 lakh round once a year? Yeah. Okay. Okay. Got it. So typical, yeah. Then I mean a proper round, which will be highly negotiated then. So information rights, you will typically have one. Start with you will have a board seat to begin with, or at least an observer right where somebody they'll have an observer sitting on the board. Specifically, information rights, you will have the rights to, of course, the annual report, the kind of annual filings and stuff. But even on a quarterly basis, some investors will say you start putting together an MIS, right? A proper information system where you have these details, which I should be able to access either kind of on a monthly basis or something like that. They might ask you for management reports on a quarterly or a monthly basis. Typically, you should, as a starter, as a very early stage company, you should spend time in negotiating this clause because if you take up too much, it is an administrative hassle for you. It can become very tricky and even expensive if you have to set up an MIS with a good auditor and stuff. At times they will even dictate the auditor. So they will say you have to go to a big four or you have to go. So those are the kind of things I try and push back on. So I will typically not agree to a monthly report for sure. I will typically not even quarter MIS also very early stage I may not want, though at times it's great value for the promoters. So, I mean, I would encourage you from an organizational perspective, but from an investor perspective, I'll not. Yeah. From a, so quarterly reports and stuff is usually where they come down to, or half yearly. Yeah. What about tag-alongs and drag-alongs? So depends on what size. 15 lakh round, 20 lakh round, 50 lakh round, no way, right? A tag-along maybe, because what the tag-along says, so I'll just explain what a tag-along right is. When the promoter is exiting from the company, selling his shares, the other investors can tag along and force him to also cut a deal for their stake in the company. It's important for an investor. Why? Because if I'm investing in the company because you are there, I know you, I trust you, right? If you exit the company, one, it's a red flag for me, what's going to happen to the company. Second, there's no reason for me to be in the company, so I should have a right to go along with you. A drag along is very scary. A drag along is, as the name suggests, you are able to drag the promoter out. I, the investor, find a deal for myself, I cut a deal for the entire company, I force the promoter also outside. I will never agree to a drag along, even in larger rounds, unless, except for in certain scenarios, so, which are called the exit scenarios. I'll come to that in a bit. So tag along, maybe tag along is still fair, is still understandable. If it's a very small round, I may not give a tag along because it also makes my deal difficult. If I have to cut not only my 50%, but also your 20%, it makes my deal more difficult. So I will push back, but I may have to agree on it because tag-alongs are fair ultimately. The nature of tag-along can be negotiated. Some investors say, you may be selling only 20% of your stake. You sell my entire stake. I would want to negotiate saying, if you're selling your 20%, I will also sell only your 20%. I'm not going to give you an exit for the entire stake you have. So I make my deal easier then, right? That's on tag-along. Drag-alongs, a complete drag-along I'll never agree to, right? I will never give somebody else the right to sell my stake out. But in certain scenarios like exit, where drag-alongs come into play, what happens is investors say like, listen, you got to give me and find me an exit in a reasonable amount of time, maybe 4 years, 5 years, 6 years, 7 years. 4-year exit could be by way of an IPO. It could be by way of somebody else buying into the company or buying my stake. Now, sorry? A what? Or acquisition of the company. Now the thing is, if you are not able to give me the exit, then then there are a couple of things which the investor is able to do. First, he may be able to drag you out. Second, he may be able to, the various actually parameters. But talking about drag along first, the issue is, firstly, if at all I'm giving a drag along at that stage, I would still want to firstly have a reasonable exit period itself. I don't think 4 years is reasonable, for example, and 4 years actually you don't even see in the market. But increasingly the time period has becoming shorter and shorter. So what earlier we used to negotiate 7 years, even 10 years at times, 7 years, now investors have begun to ask for 6 years or 5 years. And why are they doing that is also because some of the bigger, it's actually very interesting. Some of the bigger VC funds are actually coming to the end of their life cycle, right? So typically when a fund is set up, they set up for a life of 7 years or 10 years, within which time period they have to close their investments, exit from their investments, and give returns to their investors. Now, if they are coming to the end of their own life cycle, they want to start making exits. And that is why they say that, well, because I am 3 years away from my exit, you also got to give me exit within 3 years. So that's where I think we are seeing shorter and shorter exits, but it's very important for you to negotiate a reasonable time period. Otherwise, it becomes very tricky. What about it? Okay. No, you can do that by all means. The problem is you have 20 people to deal with, right? So one, it is difficult to close the round. Second, think of reserve matters. Where you want to change the nature of the business, you have to go back to the investor for consent. You go to 20 people to do that. Or you want to raise another round and you have to get 20 people to sign off, right? So that's the tricky part. We can still make it easier by what we can do is we can say that, well, there'll be a lead investor and the lead investor will take all decisions, or there will be we need 50% investor consent only. So we can work around that, but it becomes tricky. So I would not want very many people putting in very small amounts of money. No, no. So we are lawyers for startups. We are not a tech company or a startup business in that sense. We are lawyers or legal advisors for startups. Self-funded, and thankfully we have revenues. Thankfully we have revenues. People pay us. Yeah. Yeah. So indemnities are again tricky, right? So technically, I mean, I would like to not give any indemnities, whatever. So does everyone understand indemnities? You're basically saying that, well, if there is a particular event that occurs and there are losses to the investors, then you have to indemnify the investors for that. See, one indemnity you might have to give is indemnity to the directors that have been put on the board by the investors, so the nominee directors. Other than that, there might be certain indemnities which are more reasonable, where investor says like, well, but technically speaking, uh, investors are merely shareholders in the company, and they don't really run liabilities as such, or the risk of liabilities as shareholders. What is more important is indemnities for their directors, etc., which is more kind of a realistic possibility. But one thing that you need to keep bear in mind is so things like tax, for example, where there are two or three things where they typically will ask for indemnities. One is you have given a certain set of reps and warranties in your shareholders agreement. What are these reps? Are basically statements um, that you make, representations you make, which you hold out are true. So, for example, if I am say a manufacturing company that's raising an investment round, I will typically give these kind of reps in my investment document. I'll say, firstly, I am a validly incorporated company. I have received no notices threatening litigation. I do not have any litigation in the company. I have not committed any violation of income tax provisions. I have paid my tax on time. I've done the filings correctly. I have no notice from the tax department. I have not infringed on anybody else's IP. My factories have all the right permits, all of that. So the investor will typically do due diligence in your company anyway for these kind of things, but they will also take these representations from you. They will also ask for an indemnity should it be found that you have actually breached or given an incorrect representation, right? So they will get an indemnity saying that if there is an incorrect representation in the agreement, because of which there is a loss that they take on their books, then that loss needs to be paid out. Now this becomes, so two things to be taken care of. One is when you sign up to these reps, some promoters I've seen are a little too casual about these reps. They sign whatever document comes their way because they're more than happy to just be raising a round of funding. But these reps should be very carefully reviewed. And if there is something where you are not supposing, I mean, if you have received an income tax notice, please disclose it in the agreement. Don't give a false rep, because that can create a lot of problems. So that is one thing. Also, so the indemnity clause is generally negotiated, keeping in mind all these things. Definitely an important clause to look out at. Oh, the Income Tax Act, yeah. I don't think you should be giving a representation, giving any kind of an indemnity for that. Basically, so have you come across that situation? Yeah, yeah, yeah. No, is he asking for an indemnity in the event of a down round or for the current investment round? So I would not want to do that. I mean, maybe the investor leaves you with no choice. And let me just explain for the benefit of the group what we're talking about. So basically, this is something which may be applicable to everybody here, which is uh, a tax implication on either the company or the investors. When you do a round of funding, uh, which is at a price per share higher than the fair market value of those shares, the company is benefiting here, right? Because the company is able to sell its shares at a price which is higher than it should have been in the fair market, in a fair market. Um, So company is benefiting, and therefore the income tax law says that you pay tax on the differential. Okay. If there's a reverse situation wherein the company is issuing shares at a discount to the fair market value, then the investor is benefiting because he's getting it at a discount. So the law says the investor should pay a tax on that. All right. That's the broad this thing. Now, this is something you need to bear in mind. Often what happens is that, especially in the times when we were doing rounds in quick succession, what is the fair market value? Typically or theoretically is the value at which you did your most recent round. Now imagine 1 month later I do again another round at a much higher valuation, which is what was happening last year. So people were continuously doing rounds at significantly higher valuations, and the income tax department was wondering, well, I mean, how can you justify a spurt in the fair market value of shares so often? So they would say, your fair market value is what you close 1 month down, and I'm going to tax you at the difference between your current valuation and the valuation 1 month back. Right? That is the thing that you need to often work with CAs or lawyers to figure out and address against. But now, especially in your situation, what they're saying is, if you do an anti-dilution round where we're doing a down round and you issue more shares, obviously at a discount, there's a benefit to the investor and the tax should be paid by the company. Yeah, you are already doing a down round, and then the company takes such a big hit in paying cash, not even like shares at a lower value, but also paying cash from the company. I think it will make it difficult for you to do the next round. If at all you are desperate enough to do a down round, the incoming investor will be even more skeptical that, that this guy will also end up paying tax from the cash pool of the company. So one, it will make the investment round difficult. And second, yeah, I mean, I would rather not do the round. You should use it as you should actually make it a deal breaker and negotiate very, very hard. If you have no option but to raise the round, then well, go ahead with it. But yeah, it's difficult. And then make sure you are doing it at a realistic valuation currently, because if there's a down round, then it's problematic. Yeah, I mean, so CAs can, yeah. So CAs will typically give you a certificate. No, but the certificate doesn't guarantee that you won't pay tax. The certificate is only saying that, well, somebody also, along with me and my CA also believes that this is the fair market value. That doesn't mean the government will agree with you, right? Sorry? If the government agrees with you, yes. If, no. They do, yes, they do, because no, that's different, right? I mean, that is, oh, you're talking about the Startup India tax certificate? Okay, that's a completely different issue that we're talking about. We're talking about the tax not on your income. There's not income tax. The Startup India tax is the income tax issue. You're generating income from your business, from selling things, from selling services, you don't pay tax on that. That's different. We are saying that even the act of raising an investment, that there's clarification. Nobody says, they've given some clarification, yes, but it doesn't say that you don't have a tax implication. The provision is still there. Yeah, of course. There's clarification that I know, but I'm not very clear on that. Yeah. Any other questions? Shall we, what time is it? I don't even think. 5:59, we have just 1 minute to go. Good terms of use and privacy policy. Very, very quickly, I'll close this. Most people don't take this seriously, and maybe you can get away without taking this seriously initially. The thing is, one, a lot of you probably don't know that the law requires you to have a privacy policy. It's mandatory. If you're collecting any sensitive personal information, so any information about a person, say address, any information which can help you identify an individual is sensitive information, you need to have a privacy policy. You need to have a grievance officer whose number and address is displayed on the website. You need to make sure that you have, you display your security procedures that you're following to safeguard this information on your website, stuff like that. The other thing that I'm increasingly seeing now is particularly with intermediaries, for example, if you're an intermediary who is posting content, third-party content, if you don't have the right terms which clearly say that, well, I'm not responsible if the content provider is infringing IP, I'm not responsible. If you are offending somebody or you're defaming somebody, I'm not responsible. If you don't have those terms, I think you have lesser of a case to go to the court and say that in fact, you don't have a case. If you are in that situation, then you will probably not even qualify as an intermediary, and you might have issues there. So break standard form contracts. Well, I mean, this is just more of a tip rather than something which is a red flag. Is that it helps if you put in some thought into your contracts with your vendors, with your customers, etc. And if you templatize them, working with a lawyer, but create smart templates, which you can then just speeds up and brings in efficiencies into the process. Account importing. I think we touched upon some bit of tax. Of course, I mean. Yeah. Can you come again, please? Right. You don't need to register the contract. What you may need is to pay stamp duty on the contract, right? It is typically for smaller contracts, or for most contracts, it will actually be a fixed amount unless it exceeds a certain value. But for contracts like your shareholders agreement, etc., share purchase agreements, it becomes a function of the total amount in question. So that's something which varies from stake to stake, from the type of contract. So there are a number of parameters to it. No. So a contract is still legal. The problem is that if you've not paid stamp duty on it, you cannot present it before the court as evidence. So if you have to pay stamp duty at that time, it will delay the matter, and you will also have to pay a penalty, right? Which could be even up to 10 times of your the amount that was in that you should have paid. So so it's ideal to pay stamp duty, but I'm not saying. But it's not that the contract becomes invalid. Because if you don't have an option, I mean, you don't have an option, right? But often, unless the negotiating, if the bargain is unequal, if you are dealing with a PayU and or a Paytm, and you are comparatively way insignificant in the scheme of things, they are not going to budge, likely, but that doesn't mean you don't try and negotiate. And we do deal these contracts where we are able to negotiate things from time to time. But if that's not the case, don't take the point where somebody says it's not negotiable. Everything is negotiable. And ultimately, if the guy wants to do the business, does it on your terms or does it on mutually agreeable terms. But there are other hacks which you can apply from time to time. What I would do if I really do not like a particular provision, and this is not something which is it's like it's not mainstream legal. It's just a hack. I would at times try and record the disagreement somewhere. So I would just drop an email to the other guy saying that, listen, you know what, I don't agree with this, or I agree with this, but in a certain context, but this is what we discussed. I will record the stuff so that if tomorrow I have an opportunity, if we go to the court, or even if it's a mutual agreement, I can present it before the court and say that, listen, we had actually never agreed on this, or there was a disagreement on this one particular clause, or there was a difference in the way we interpreted the clause when we agreed to it. So there are some, if it's really that material to you, you may want to at least record some of the stuff somewhere. And I've been able to use it once in a while in situations which have become disputed. But yeah, ideally you should just you should try and negotiate the contract itself. Sorry. Yeah, I mean, see. So this goes back to the question of what is a contract, and a contract does not necessarily have to be even written, forget signed. Even an oral contract is recognized. Yeah, I mean legally enforceable. An oral contract, if we enter into a contract today verbally, that I will sell this thing to you for 10 rupees, and you agree to it, you consent to it, provided I can prove that in the court, the question is only of proof, right? It's difficult to provide proof of a verbal contract. But if it's a written contract, so if it is written contract on email, for example, or it's a contract which is properly signed using a third-party service provider, absolutely it's enforceable. Questions could arise around payment of stamp duty and stuff like that, but generally speaking, it's enforceable. We use it all the time. So, I'm sorry? Points to be taken care while acquisition. What kind of, you are acquiring somebody or you're being acquired? Somebody is acquiring you and the nature of the acquisition itself, right? So is it an asset acquisition? Is it an acqui-hire? But irrespective, one thing that you will always do is give a lot of representations. Because the guy is buying your company, he wants to know that you don't have liabilities, you've not received notices, you don't have litigation, right? So reps, indemnities, he'll ask you for indemnities. If tomorrow a rep is untrue, if tomorrow there's a tax liability on you, you need to indemnify. That's another point you need to negotiate. The same kind of situations will come in. They will make sure that you don't compete with the business. So similar situations. Then of course, I mean, that's something we can, have a completely separate session on because there's just so much that goes into an acquisition agreement. Okay. Can you, sorry, can you just break it again and just one line? Yeah. Yeah. Oh, so can they not do it on the website? That's what you're saying. No, of course you can do it on the website. Um, yeah, you can. There are 2 or 3 things to it, right? And a lot of contracts are signed digitally anyway, with the tick the form and stuff like that. One is a psychological issue. Does your customer tend to take a paper contract more seriously that he's bound by? Is one question you need to ask yourself. Second is both a psychological issue as well as an issue that could play out in the courts, which is the fine print. Typically, the tendency is not to read digital contracts, right? None of us have read any of the contracts we signed up online. The thing is, if this goes to the court and somebody is able to take the argument, and they will take the argument, that, listen, nobody reads these agreements. I didn't read these agreements. It's 3 pages. It's difficult to read online. It was in fine print. I didn't read it, right? There is a possibility. I mean, and there are no judgments to this point, but there's a possibility that it could work slightly against you or not in your favor. Those are some of the kind of points around it. But generally speaking, see, theoretically, technically, yes, digital contracts are very much valid, no doubt, and they're also recognized by courts. But these kind of issues do come up around it. Yeah. Yeah, yeah, yeah. So both valid and invalid. Valid to the see. Okay. Again, what is a contract? A contract is there has to be definitely a meeting of minds. If both of us don't agree to what we have, well, if both of us have not agreed to the same terms, there's no contract. All right. So theoretically, I have agreed that if you change your terms, I have notice of it, then I'm deemed to have agreed to the change terms also. Practically speaking, somebody could argue in the courts and may even succeed that that's not how contracts work, because you change the terms, so there is no actual agreement on the terms. But the thing is, the way we draft those contracts is typically we try and give notice. So often you will see is that the moment there is any change on the terms, you will get an email, and that email will say, we have changed our terms. Here's an attachment. If you come to the website once again, either you don't come to it. If you've come to the website, then it is deemed that you've agreed to the revised terms. So that's how we take care of that. Oh, absolutely. In fact, I may even want to get you to sign it once again. Or I may even highlight, if I want to go a step further, I would even highlight the changes separately, or it pops up as a pop-up on when you come. So a lot of these practices are not typically followed by people, but it's absolutely important because I'm damn sure that once these matters go to the courts are going to take a very hard view. You ought to, absolutely. I mean, otherwise there's no evidence of somebody agreeing to the terms. Yeah. No. I mean, again, see, okay. Technically it is because, I mean, you always have the option to uncheck the box. But practically speaking, you shouldn't. In fact, as a default, you should check the no box because it just shows that the guy went the extra step, right? To uncheck no, check yes, means that he's kind of taken the effort, he's agreed to it. Sure. Okay. What kind of activities are these? These are what kind of activities? Physical interactions? And no, but basically you sit together in a room and in a physical space and do some activity together. Sure. Okay. Sure. No. So no patents whatsoever, right? Copyright, because copyright is the IP for literary work. Okay. Now, yes, you could copyright any kind of literary work as such. Uh, but again, as I said, somebody could pick from your content. It's the same thing like with a book, right? If it's a book and somebody else takes the pain, and it's not easy to do that, but takes the pain to kind of modify it appropriately, and it cannot be shown that he's substantially picked up from the same book, he may be able to get around it. But if you have 100-pager, it's very difficult to really do that, for somebody to copy all of that and still establish that he didn't really copy. So, yeah, sure. Yeah. Yeah, I mean, absolutely. Even if they're not copyright, by the way, you still have a right over anything that you create. I'll give you an example. We get this. We work with a lot of edtech companies. The companies we do content on so FAQs or question answers. Now, who would imagine? Forget question answers, just questions. So if you have picked up questions from the last 10 IIT JEE exams and put it together in a booklet, can you claim copyright over it? Maybe not. But you have selected the questions. You selected some 20 questions, 200 questions which you think have a certain kind of merit to them, right? And you placed it. Can somebody copy it as is and start selling it? I don't think they can, right? Can they? They will have to make significant modification, even though the questions were not really generated by you, but you've put in the effort, a creative effort, in putting it together in a certain form and format. So that has value in law, and it's respected. We had a 2-hour chat. What do you think? so, so no, sure. I mean, listen, no answer with that, right? I mean, how do you get comfortable with anybody then, with a co-founder, with an employee, with a lawyer? You talk to them, ask them questions, and a lot of questions. I mean, see, what happens is and typically it's kind of true for the legal industry, as with the chartered accountant, CA industry as well, is that people generally, a lot of them are generalists, which means they don't say no to any kind of work, right? A lot of us actually do all kinds of work. We don't, but that's kind of very it's a very popular kind of practice. So typically you will run into the only way to figure out whether they have had prior experience of the industry, they understand the industry, is by asking them a lot of questions. And I hope this talk has given you at least ideas on what are the questions you should be asking. right? There's no other way to do it, right? I mean, how is it? We're already working on one actually with some clients. Yeah, I mean, those things are coming up for sure. I mean, yeah, we're working. It's a big market because last year actually we saw a lot of secondary transactions. There were a lot of transfers, stake transfers, a number of because also what is happening is that, as I said, a lot of VC funds are coming to the end of their life cycle. Therefore, they want to exit stake. So one investor is transferring stake to another company, another fund. That's happening a lot, and you will find these people, platforms which enable those kind of transactions. That's definitely in the op. We are 9 of us. Yeah, a lot of them. I mean, Bombay, a lot of our. Yeah, I mean, when you work a lot with startups like we do, obviously, we work at rates which are, you know, I mean, which work with startups, obviously. So we keep that, we are cognizant of that. But at the same time, if you want value, you got to pay for it, right? I mean, you want a Ferrari, you pay for it. Hey, you can't say that after the 2-hour talk here. Nothing is standardized here. So just to give you an example, uh, uh, your if angel term sheets were standardized, well, if co-founder agreements were standardized, everybody here would have had a co-founder agreement. Nobody does. If angel term sheets were standardized, why would we be talking about negotiating the liquidation preference or anti-dilution? No question, right? Like what else? Like what else? Okay, yeah, I mean, so unless if you're dealing with a very critical information, we will actually spend time even on your NDA. But if it is general, usual course stuff, by all means, use a standard NDA. See, also, a good advisor will also tell you what to spend money on or what not to spend money on. Like, for example, with trademarks. My advice is don't go for trademark registration if you're not a consumer brand and if you want to just validate your business for now and you're a digital company, publish it and come back to registration when the time is right. So you also need to work with your advisors in prioritizing things. What is it that I can avoid spending money on? But there are certain things where, if it's the cost of it, right? To Eduardo Severin today, if you were to ask what would you have paid for good legal advice, $1 billion may not have been enough. So it's that, right? I mean, what do you say? I'll give you an example. One startup we work with we did their first angel round, and thankfully we did closed a much larger institutional round recently. We were able to negotiate a lower ESOP dilution by just 2% at that point in time at the angel round. Today that 2% is probably value like 100 crores. So I mean, well, not 100 crores, but sizable amount, right? So those are the kind of commercial insights that an experienced person from the industry can bring could be valuable. May not be valuable if it really depends. But yeah, I mean that's a call you've got to take. We work on a project to project basis typically. Depends. So you come to us with a project if it's a clearly identifiable project. You say we want to draft a co-founders agreement. We know how much time it will take us, more or less, and we will give you a fixed fee. If it's an ongoing thing where you need a lot of advice from time to time, we do monthly retainers. In certain situations, we've done equity models, we've done alternative billing. We structure that depending on your needs as well. So yeah, sure. I'm around for a bit. Yeah. Yeah, great. Thank you so much.
I want your help in the patent. You are helping the patent and everything, right? Because Andrea was having the patent now.
work with a lot of Bombay-based clients anyway. I mean, remotely,
When are you heading for the airport?
I'm here. I'm not trying to. You can chat. Are you?
I'm over that side, so I was wondering if you.
Why don't I do one thing? Let me just leave my cards here.
Sure.
And,
I will give you mine
whoever
as
wants
well.
to talk to me, trying to set up. Your funds, your peer funds is yes. Why don't we do one thing?
Hearing about legal secrets.
Guys, if you want to have a
I just have 30 seconds.
we can do this. So,
So,
what I'm suggesting is,
What's the best way to set up a call?
just email me and we can set up a call. If it's urgent, then we figure out. If not, then because I'm here in Bombay for the week.
Yeah.
Not end of next week, or you can always connect with my colleagues.
Okay,
as
so
well.
what I'll do is I'll just drop you an email.
Sure
If
thing,
you're
sure.
free, we can. You have an office here?
Not in Bombay. We work with a couple of people for the
How
more
often do you-
logistical stuff, but we don't.
How often are you down? Like once a month, twice a month?
Not once a month, it's more need-based, but still, come down. So usually, it's enough number of clients. I have probably 70% of my clients outside of it. So it's not a challenge. So let's get on a call if you need Skype or something like that. I've not met my clients sitting in Delhi also. Yeah. 4 years we've been working, I've not met them. So it happens. Though I like to meet people over here, but it's not possible all the time.
Thank you. I'll drop you.
Sure, my pleasure.
I'll just have a cabin allotted.
Now, I don't want to stand on this. Sorry? We advise, we will typically connect you with somebody to help incorporate because we might be a little more expensive to incorporate as such. But we are happy to keep a tab on who's working with you and guide them and stuff. That we can do. Incorporation is simple stuff. Unless it's more challenging, it's not something that you need us to help with. But if you're amending your articles at the incorporation stage and stuff, yes.
I have one. It's been a lot of time. See how things can turn around. You can take it offline longer.
You want to stay for a bit after? I'm around.
Whenever. I just want to throw this out and everyone should have to wait.
No, I'm saying if you want to stick today, I'm around. If not, then we can just chat now.
I just want to throw the thread and then I'll show you later.
Sure.
So this friend of ours, it's part of the banking industry. Good collective minds from a lot of places. Some kind of fund or some kind of accelerator to get pool our collective minds together.
What is setting up an accelerator?
Something of that sort, right? What would be the thing that you could set up first? Like what kind of body would you set up? Is it a corporation? I don't understand.
No.
In Indian scenario, what would it be?
Typically you will set up a class. So it's a very different kind of and this is something which maybe we can have a chat with my partner. I have also done a bit of PE fund formation, but things are not but a trust is way for tax. So a tax is not tax. And in the sense that you don't have double tax. You never have sort of that's one of the key reasons why we do it. But you'll also require depending on what exactly you're doing. I know funds were at a smaller scale. Start about it.
Carry on. You're still around.
Yeah, I'm going to be around here.
Maybe you have a chance.
Yeah, sure. I'm here. Okay. I'll be here, but catch up with you. 6%.